Hey everyone, I'm Kevin Gosztola, managing editor for Shadowproof, and it's good to be here sharing with you the update, the reports that I have for today. And we had a day of two witnesses again testifying on the testimony about U.S. prisons. We had Lindsey Lewis, who is an attorney who has represented Abu Hamza, who was accused of terrorist offenses and ultimately convicted in the United States. He was extradited from the UK, and she had testimony to provide about the assurances that the US government had made to the court in the UK about whether or not Abu Hamza would be put in a supermax prison. We also had Maureen Baird, who's a former warden of the Bureau of Prisons, of a facility. She was the warden of MCC New York, and also had some experience at a communication management unit facility in Marion, in Marion, Illinois, at the Marion Penitentiary there. So it was an important day to put on some testimony. It actually was a much better day than yesterday's proceedings. Joel Sickler's testimony as a witness about the conditions of the Supermax and some other facilities, and his more general testimony about what it is like in the Bureau of Prisons and how they manage the facilities was something that didn't go over quite that well. It was a little, I wouldn't say unreliable or not credible, but he didn't have a lot of firsthand knowledge. He was only able to speak as an advocate. But here we had Maureen Baird, who is a warden, who has been on the inside, who's been part of the system and was able to speak to a lot of critically important issues that Julian Assange would face if he was brought to the United States and he was put under SAMs, the Special Administrative Measures. And so she took the stand, and she had been in this leadership role. She was for 2 years, from 2014 to 2016. She was at the Metropolitan Correctional Center in New York. And then at the facility and for the CMU, she was there for a few years before retiring. And she testified about how he would be a national security defendant for probably 23 to 24 hours a day, would be kept in a cell. That was her experience. She had handled mostly pre-trial SAMs, so the people who would be put under SAMs. And so, if he's at Alexandria Detention Center, Assange would be put under SAMs there, likely go through a similar regime. What she said seemed to match what we heard from Yancey Ellis yesterday, a public defender with experience in the Eastern District of Virginia. He's somebody who spoke about representing people who had been held. He was someone who could speak to what it was like in the X block there in the Alexandria Detention Center. And so everything she said mostly matched, that this unit called 10 South, where these people would be housed, you would be there essentially in solitary confinement conditions. Your recreation would be in another indoor cell. You don't really get let outside. There might be an exercise bike in the facility. There may not be anything there for you. You might have to make up your own recreation. It would always be alone. Phone with a family, likely one call per month to a family, or maybe you would get to make two different calls for 15 minutes. So yeah, you'd have a choice of having 30 minutes. You'd have 30 minutes. You could do one or two calls, was essentially her testimony. And again, we're dealing with the assertions by Assistant U.S. Attorney Gordon Kromberg about what these conditions will be. And each of these witnesses are pretty easily capable of showing that these are false or deceptive representations that are being made to the court. And so Baird, Maureen, she addressed this fact that He says there will be free-flowing mail that would be coming in to Julian Assange if he was held in this facility, that this would just be free-flowing, incoming and outgoing. She said all mail coming or going out from any one SAMS inmate is screened before it ever gets to recipient. And sometimes that can take a couple months, maybe longer, to receive a piece of mail going out or coming in. So that's not really free-flowing. It would be disruptive, and any messages would take a really long time to get to Julian Assange. So she gave some testimony laying out her belief again that Julian Assange will be placed under SAMS, that he falls under that criteria as a national security defendant. What is the nature of this? It's restrictive. Some of this is repetitive. We've been hearing a lot of this over the past week. She got into this thing of not really understanding how Gordon Kromberg could outline this program in his submission to the court about how inmates could get to a certain point where they had the privilege granted to them to meet with other people, to socialize with other inmates, to be in group. And the reason why that's unbelievable is because it says that you'd have to have your SAMS modified, that you'd have to get some administrator to change your designation. And there hasn't been any evidence put on the record that shows that this happens. It's very rare, to be extremely rare, for somebody who was designated with special administrative measures to then have those removed post-trial. And hard to convince a court or anyone that these should be challenged. We heard lots of evidence about trying to litigate through the administrative remedies process. And this is an administrative process. And obviously in the name administrative remedy, that's clear. But what it means by administrative is it exists outside the court. So in the prisons, they don't have any intervention from the judge. They make their own decisions about whether what a prisoner is saying is valid or not. And then after all the remedies are exhausted, all of your efforts to try and challenge your confinement conditions are exhausted, which should take a long time. Well, what could happen is, in the case of Abu Hamza, he was at MCC New York, and then he got moved to ADX Florence, and it reset. And he had to wait another year or so, exhausting the administrative remedies. Again, raising some of the same complaints, but those complaints he couldn't immediately go to a judge and complain about, which we heard evidence today from Lindsey Lewis that he is complaining about. It's good here. I will say the organization of this day is good because we've got two witnesses that can complement each other. Their testimony go together well. It's very helpful to understanding this aspect of what the defense is trying to challenge and put before the judge. So we've got this claim from the prosecution that is, I think, wholly disproven, that somebody can eventually get, if they have good behavior, they could get a chance to socialize with other inmates under SAMS. That defeats the purpose of having special administrative measures. If you have SAMS, then you're supposed to be isolated. You're supposed to not be able to socialize with other people. So you would not be able to work your way up to being with groups of people. And in fact, the policy says that it has to be changed. So they are playing a deceptive game with witnesses, and I'd argue they're playing a deceptive game with the judge. And so we had Maureen Baird complete her testimony. Claire Dobbin was again leading the cross-examination. During her cross-examination of Baird, I want to make sure that that I'm emphasizing the way in which she was treated. It was kind of a trial within the trial. At a certain point, Maureen Baird seemed to be accused of allowing cruel and inhuman conditions to persist while she was the warden of MCC New York, even as she gave testimony against those conditions. And she's now committed herself to helping defendants on sentencing, to help take care of them, make sure that they are given an opportunity to mitigate the kind of abuse that they might experience within the system. Still, she takes a stand. She starts to describe what it was like, and we get into this. Claire Dobbin pressured Maureen Baird to accept that she could have done more to force correctional officers in MCC New York who patrolled the 10 South unit where Sam's detainees were held, to patrol it and make sure that they were engaged in more talking, that there was conversation. He kept saying, when people who are Sam's detainees are not meeting with friends or family, you could have two officers. You could have one of the officers who are patrolling the unit. They could go and they could engage in conversations with inmates in that unit. And she said, well, that's just not what correctional officers do. And Dobbin maintained she was in a leadership position. She could encourage them to have these conversations. So I suppose it would take the edge off the solitary confinement you're experiencing. But, having a correctional officer without any trained experience pretend to be a counselor is not something that I can fathom. I almost wonder if there was even conversation. Would the person who is detained under Sam's find it abusive to have this officer try to talk? I mean, if an officer was told by their warden to go talk to prisoners, what kind of conversation would that be? And would anyone really want to engage with any conversation with that officer who could be hostile, very contempt-filled about who they were talking to? So Baird said, well, there's cells. The cells have a steel door and there's a viewing slot, but that slot remains closed, and the officer typically opens it and moves on. And Dobbin kept saying, you could encourage conversation. So she had to defend herself, and she said, yeah, I did. I'd go down there. I might bring an interpreter if it was necessary. I would make my way past all of the detainees, and I would talk to them and see how they were doing. I'd do my wellness check, essentially. And then Dobbin clearly was not accepting of what she was saying. So she also mentioned that the officers are in a union, and if I told them that they had to converse with the inmates, and they would tell me that is not in the job description for what they have to do. So at that, Claire Dobbin was she was rather annoyed with what she was hearing, and she continued to press. And so we had this play out, and I don't know if Baird was right or wrong, but I certainly understand where she was coming from. And she said that it was not something she felt she could enforce to make sure that correctional officers were talking to these detainees. Again, this seems very minor in the scheme of things when you look at the whole picture of what solitary confinement would be like in one of these facilities. And then, we get a full indictment of her character, even though this isn't a question. She just flat out comes out against Maureen Baird in the middle of court. Claire Dobbin does, and says, you didn't encourage staff to talk to people. You never raised concerns about this to the BOP, and you didn't speak with judges about inmates on the SAMS unit. So essentially, you never became a whistleblower. You knew it was inhuman, but you went along to get along, and you never became a whistleblower, which is just terribly rich coming from the prosecutor to hold this against her, when this is exactly the kind of kind of woman that they want people to be who are running these facilities. This is the culture. This is what is expected of you. And she's left it, and she has questions about what she was asked to do. And, she even said, it did cause me concern, but I had to convince myself it was okay. When she was told that, she had experienced, she had managed these conditions, and she was only concerned with them now that she has been asked to provide evidence to the proceedings. This is what she said. It suggests that, she has reflected on what she was told to do as a warden, and she regrets perhaps causing cruelty in a number of ways for advancing a cruel system, for being involved in that. We got to the lunch break, and then we brought Lindsey Lewis on, and Lindsey Lewis came on and talked about the Abu Hamza extradition, and she's representing him in his complaints related to prison and medical concerns in the Supermax facility at ADX Florence. She hasn't been able to visit him there, but she's got quite a lot of experience with correspondence, trying to talk with him, communicate, mail, talked with him over calls, schedule those calls, and she could speak very definitively about the representations that were made to the UK courts about what was claimed related to whether or not he would be put in a supermax. It became clear through this testimony that, in fact, a warden had suggested he would not be there for any longer than short term, or that also he would be there. Let me backtrack. He would receive a medical evaluation, and if it was found that he was not capable of living, doing daily activities, then he would be moved to another facility so that he would not be abused in Florence. But that hasn't happened, and it's been 8 years, I think. It's been 8 years, and he has been, he's had 8 years on SAMS. So I think 2 of that is pre-trial, and he was convicted in 2014. So we have 6 years that he's been post-trial in the special administrative measures, and he was brought to Supermax. So he's had multiple years now that he's been in these conditions, and it's far longer than short term at this point, because we're looking at 6 years that he's been confined, and he's an amputee and has a lot of physical ailments. And he was given a cell for people with disabilities at Florence, but it's actually not outfitted for someone with his disabilities. So it's not really of much use to him to be in that cell. And he has to do his own complaints. And he's still a lot of matters. He's got to navigate the administrative remedies system in order to bring challenges. And then the courts are slow, and it's hard to get them to move on any issues, which how this relates to Julian Assange is that it doesn't inspire confidence that if he had something that he needed to raise with a court, he would be able to do so. So before I get to your questions here, let me address what happened at the end. There was an effort to convince the judge that they should grant anonymity to the witnesses who are going to be providing testimony about UC Global. Undercover Global is the private security company in Spain that engaged in an espionage operation against the Ecuador embassy. And so they were asked, he asked the judge, Mark Summers did for the legal team, could you protect these witnesses? They have protection in Spain. The Spanish court has even given them armed protection out of fear of what David Morales, who is the owner of UC Global, might do. Apparently, when his home was raided, they found a gun. The ID for this weapon was rubbed off. So, what were you planning if you wanted that weapon to not be tracked? There's, of course, evidence that UC Global at the top, involving David Morales, had plotted to poison or kidnap Julian Assange from the embassy. Violence. Right now, it also was pointed out that there is such a small universe of people that know these individuals, and that protects them. So it was a smaller company. David Morales probably knows who the 2 witnesses are that are testifying against him, who are involved in this case against him in the Spanish court, but we don't know, and the larger public don't know, and that name is not a public name, which means that if something terrible would happen to the witnesses and they would be hurt or killed, we would know exactly who did it. It would be David Morales, because David Morales is in the small universe of people who know who these individuals are. But if you reveal their identities, then you can't really protect them anymore, because everyone knows them, and who knows who might be using the cover of that to commit some kind of acts And we believe that this operation links back to U.S. intelligence, but the government's position is that they're going to neither confirm or deny that there's any role on the part of the CIA. We heard James Lewis speak at the end of court about the so-called Chinese wall that Gordon Kronberg preaches, that if it's possible that an agency is implicated, they're not going to have conversations with that said or particular agency, which means they can't go to the CIA and consult on this. It's very convenient. And then they don't really have to get into it. So what they're going to do with the UC Global witnesses is to say that it's just irrelevant testimony. It doesn't matter to the case. That's what they're going to say to the judge. And the judge says, you know, do you want to take a chance on me making a ruling on that? Because they don't really want to do any more. I think what's going to happen is there's no cross-examination. So because they can't really speak to the substance of what these witnesses are saying, since it would require confirming certain details, they're going to keep a distance. We're likely to see that these witnesses enter statements into the record. I don't know that we're going to have live testimony from them. And so then the witnesses will provide their statements. They'll be read. We'll get all the important, crucial information that we need from them related to why Julian Assange should not be extradited. And the position is going to be toward the end here that James Lewis and the prosecution say to the judge it's irrelevant and you shouldn't factor it into your decision on extradition. And then, but we'll know, I mean, crucially, we'll know the information. And if it's not important to the judge, that will be something we can use in our commentary and the way that we reflect on what has happened in this case. Certainly, it's really important in Spain. The courts have taken up this case about the privacy offenses that were allegedly committed and looked at the conduct that these players were involved in. So I've got some time to take a few questions before I wrap up. And let's see what you all are up to. I see Jeremy was excited, thought it was a good day, a much better day because of the anonymous witnesses that UC Global, they were granted anonymity. Testimony from Baird and Lindsey Lewis was good. The judge did stop. You know, at one point, the judge actually did stop Claire Dobbin because she said to Lindsey Lewis that the suicide rate of, I think, 10 out of 100,000 people is a low rate. And this was, it wasn't Lindsey Lewis. It was Maureen Baird. Earlier in the day, she put to Maureen Baird that the suicide rate was low, 10 out of, I want to say 100,000. And Maureen said, well, I think one is one too many, and I don't know I should pass a judgment on, whether 10 is an acceptable number or not, something to that effect. And Claire Dobbin didn't want to accept this answer, but the judge said, I think she answered your question. She told you that one is too many, and she made her move on. And, I kind of want to choose to believe that I heard she's right. One would be too many, but I'm not sure her British accent, she might have been saying rate and not right. But for a moment, I wanted to believe that she acknowledged the mere fact that one suicide is one too many in the system. So let's see. Any questions that anybody has for me, and then I will be wrapping this. I'll be putting together a written report. It looks like there's some really good material to go over from Lindsey Lewis that has some bearing on what could happen with the extradition, given the representation that was made about Abu Hamza that turned out to not be true. So I feel like that's where we are with Julian Assange, that we are hearing things said to the court that will be very easy for the U.S. Justice Department to claw back in the event that Julian Assange is successfully extradited to the United States. So, is Lewis QC a Red Dwarf fan? I don't know that I am capable of commenting on that, but I appreciate the question. How about I just hold on to it? And if I'm ever capable of answering it, I will give you an answer. Is there a central location for all the statements read into the record? So, Tariq Haddad, TareqHaddad.com. I understand he's been posting all the statements in one location for people to look at. And no, I think you're the first person to ask that about where to find the witness statements. And so, all right, I'm going to wrap up. I've got to work on the report that will be published today. If you would like to receive it, we've got just a few more days. We learned today that we might end up wrapping early. We might be done on Thursday. There's been some conversation back and forth between the prosecution and defense. We're going to start the morning tomorrow reading witness statements into the record, which is going to be hard to keep up with. It's much more difficult to tweet and transcribe and keep up with witness statements than it is to keep up with the live testimony, but I'm going to have copies, so I guess I really don't have to scramble to get it into, I don't have to scramble to keep up with it really yet. So there's going to be the morning for that, and then in the afternoon, we're likely to have Andy Worthington, a fabulous journalist, done tremendous work on Guantanamo Bay. He's going to testify about the detainee assessment briefs, and they could not agree on his testimony, so we're going to get to hear from him, and that's great. And then I know that Noam Chomsky, Patrick Coburn, Middle East correspondent, and some other people who are recognized and are known to some people, they are going to have their statements entered into the record at some point. I don't know if that means tomorrow morning. We've got a few legal statements that will be put in, one from Gareth Pierce, who is on the WikiLeaks legal team or the Assange legal team, and that'll be entered into the record, dealing with some abuse of process matters. And tomorrow will be a day, I think, where we go through a number of witnesses and get that number down considerably, because I think we're at about 10. I believe we're at about 10 witnesses left for getting through in the next 2 to 3 days. If we include the 2 UC Global witnesses being 8, then take out Chomsky, take out Andy Worthington, take out Pierce, take out I understand there's Ian Overton and a couple other people. Once you get through all of those, then we can wrap and the defense can get on with putting together their closing arguments. Just a reminder of the timeline. We're going to have 4 weeks. There'll be 4 weeks where the defense will be putting together their closing argument for the court, submitting that. The prosecution will then have 2 weeks to reply, and then the defense will have 72 hours to reply to whatever the prosecution provides to the judge, and then the judge will have all of her material, and she'll spend the next couple months, pretty nearly, probably a month and a half when you get down, and in January we'll have a decision. We were told January 2021 for a decision, and I understand it was reported that because it was coming after the election, that there might be some proof that this is a political thing, that it's being delayed. Let's clarify that no matter what, it was always going to be a decision after the election day in the United States. I don't see how it would have ever been possible for this court to issue a decision before election day, so I don't believe that we can bring that into it, even as much as this is a political case. So thank you, Rob. Thank you, Anthony. Oh, Anthony, can you appeal to European court? Yes, he will have multiple options for appeals and will work through the system. I think there's 2 or 3 options that can be exhausted before finally he is moved to the United States, or before he ultimately loses and would be brought to, January is a long time, but I will say that we could take care of this problem right now if the judge granted bail. She knows that that applications have been put to her, And if she truly is concerned about his well-being, because she's invoked his well-being a little bit as this has been a drawn-out process, she could allow bail, could let him out. I think they have another opportunity if just to answer one more question, squeeze in another answer to a question. I think that if he appeals with that appeal court, there's another opportunity to apply for bail. I don't know if it's a done deal that he stays in jail. And what we would have is an appeal court trial would be about abuse of process. And he would stay probably in Belmarsh where he is right now if he was not granted bail. So that's the answer to that question. I think that about covers it. You can go to dissenter.substack.com if you would like to get the newsletter with written reports for each day. We've only got 2 or 3 more days left of this after today, so four more reports potentially that will be coming out. If you want to get those, subscribe, dissenter.substack.com/subscribe. Reports are also at shadowproof.com, and I'm live updating during the proceedings at Kevin Gosztola. And if you appreciate what this journalism is and represents and all the work that's being done, throw $1 or $2 my way and help keep us going strong. Ensure that we'll continue to be able to do coverage of this, as well as the decision when it's announced and any hearing there that it's a little unclear. I don't know if we're going to get a hearing where people are going to be giving closing arguments in a live setting where we might meet for 2 days. I don't know if there's going to be 2 days of argument by the defense and prosecution. So I would want to be able to cover that. And also if there's an appeal in 2021 or 2022 to cover, so all of your support keeps us strong, means I can keep covering this diligently. So thank you everyone for your support. And I will be back tomorrow, day 17, as we finish up this 4th week of the Julian Assange extradition trial.